Hello, this is Brad Harvey with Harvey Investment Management. Today we're going to be talking about the basics of estate planning, part 1. Estate planning really has to do with putting together documents of your wishes as you're getting toward end-of-life planning. So it includes things that occur before you die. Normally when you think about estate planning, you think about a will or trust documents and what happens to your financial affairs upon your death. But before we get to that, we're going to talk about your healthcare directives and things that you ought to be thinking about as part of this entire estate planning process. Why is this important? Because it's a gift to your spouse, your children, your heirs, to let them know exactly what it is that you want so that you can take that decision off of their plate. Okay, so think about exactly what you want to happen to you in the event that you're disabled in some way, or you can't speak, or you're unconscious, or you're in a permanent vegetative state. Does that mean it's the end of life for you and you want them to pull the plug? Well, if that's the case, give them the gift of making that decision for them. This can be very, very helpful. I know it's not fun, it can be a little bit painful, but it's very important to know what those goals are, and let's get them written down. The first part of the healthcare estate planning kit is a living will, and that's what you want to happen with your affairs prior to your death. So it's living. Upon your death, that's a whole different story. As part of that living will, you can also have what are called advance directives, or a do not resuscitate order, or kidney donation, or anything like that. You want to spell those things out in your living will or your advance directives or your DNR, do not resuscitate. In Colorado, we have a statutory DNR. It's known as a most form that your physician has to sign. And don't forget, you also need a HIPAA release form. HIPAA is the privacy law that talks about medical records and who has access to those things. You want to make sure that whoever you give the authority to make these decisions also has the ability to review your medical records and any tests that they might run for you while you're unconscious or unavailable. And you can put that authority into what's known as a medical power of attorney, or a medical POA as it is known. This is separate and distinct from a financial power of attorney. This really only has to do with medical decisions. You can join it together in a single document, talk to your estate planning attorney, and they will decide what is best for you in your situation. So this is Brad Harvey with Harvey Investment Management. That's part 1 of estate planning, healthcare decisions and directives. I hope you have a great day.